Now, I could go on and on with regard to the motion of Defendant B's attorney. His final request is, wherefore, Defendant B respectfully requests the court correct, comma, vacate, comma, modify, comma, or grant a new trial concerning all previous orders made herein, semicolon. Further, comma, Defendant B respectfully requests the court grant a stay of her jail sentence by authority of Rule 1.1006 of the Iowa Rules of Civil Procedure, period, signed by the attorney for the defendant. Now, basically, when the court got that, and the plaintiff, the Attorney General, didn't know how to argue that we can deny substantive due process of law and equal protection and our mistakes don't make no never mind, the 30 days was up and our hero gets out. Now she goes back to, should I fire my attorney? Now, when I ask Defendant B the questions that we just talked about, like, does your product contain? And then I saw the names, I said, have you submitted your product to the FDA? She said yes. I said, what did they say? She said, I wrote them a letter about 3 weeks ago, and I stated they had 10 days to answer me as to whether they found anything objectionable about all my products. And I submitted to them samples of all the products, samples of all of my literature advertising my products, and I requested of the FDA to respond to me and tell me what needed to be done to get them approved, but if they did not respond to me in 10 days, they would be entering an agreement whereby they admitted to me as a fact not to be controverted that they had no ability or duty or jurisdiction to review or regulate my products. I said, great, what happened? She said, I got a letter back from one of their attorneys in 10 days. I said, super, these people know how to stay in honor. What did the attorney for the Food and Drug Administration say? Well, there were about 3 or 4 paragraphs in the letter like usual, and Defendant B sent me a copy. I thought I had it with me. I do not. I really wish I'd have that here. Maybe I'll try to bring it next week. It's really incredible what the attorney for the FDA said. The FDA said, we got all your literature, we got all your products. Ordinarily, the FDA does not involve itself with ordinary food supplements, either for human beings or for animals. But you are not to assume or presume that this response to you or the failure of any other response by the FDA within your 10 days gives you the authority to assume or believe that the FDA has any position yet with regard to your product. And then the FDA went on to suggest that when it came to some medicines and stuff, if they were in the products either for human or for animal consumption, that the FDA did have jurisdiction and authority for review of the product. And this letter stated basically, we are not at this time making a determination whether or not your products have to be reviewed or not. But then the last paragraph did say and imply that there were issues based upon the evidence submitted by our hero that the FDA had a further interest in this, to which they could not give her a final determination. It was about that time that I suggested to this lady that her problem was the name for her products. And I said, have you submitted this same information to the Iowa Farm Group? And she said, yes. I said, what did they say? And they said they had a further interest. I said, why don't you go back, rename all your products, put in the negative averments as to the contents thereof. Do not make any medical claims as to diseases. Resubmit it to FDA and to Iowa Farm and see then if they have any interest in your products based on your negative averments, a choice of new names not infringing upon the names of diseases and copyrighted patented medicines, and see what they say then. Defendant B said she would do that. Now, I venture to say that her whole problem has been copyright infringement based on bad choice of names and the assumptions and presumptions that those names have evoked in the parties responsible for regulating controlled enterprises dealing with diseases and control, prevention, and eradication of diseases. And I venture to say that's where her whole problem has arisen from in this matter. And it's so easily rebutted to overcome those presumptions, then to accept all the fines, write them off by way of the exchange of the exemption, and proceed on with your life without fighting these people who are only protecting vested commercial interests to which she most likely has infringed. I apologize for taking all the time today, but I thought that an example of some of these things are very, very important to show people that a lot of us are making mountains out of molehills, causing all of our own problems, while at the same time we tend to be blaming the public officials for, quote, destroying all of our inalienable rights. What part of using copyrighted names of diseases and medicines is a part of Defendant B's unalienable rights? And hasn't most of her problems been created by her own lack of knowledge and her own assumptions and presumptions on her part that she has not resolved by trying to cooperate and do it in a reasonable manner with the public officials before it got into a multi-million-dollar activity involving 30 days of jail, and she's darn lucky that she got out of there temporarily, and we hope permanently, in 30 days. Let's not lose sight of reason, logic, and common sense because we assume and presume these public officials are out to take away our liberties and rights and destroy us for no reason whatsoever. Now, next week, I'm going to let Dr. Bates here present to this group on tape what they have learned about UCC1 filings, not just the paperwork per se, but the little nuances and the tricks and the things behind them that allow them to work and get filed, not just what you write down and try to force on them. Because when they show you some of the things that came out of their studies, they will show you that a lot of the people that are presenting documents the way they've been written to the Secretary of State, and then the Secretary of State coming back either in writing or verbally asking one or two questions, these people are not able to properly respond to rebut the presumptions that keeps them in honor and permits the Secretary of State to do the filings. And you will find a lot of those little tricks and a lot of those little lessons that you will understand better how to get those documents in and know what they're all about. So again, I apologize to Dr. Bates for not giving him sufficient time tonight to get on the agenda, but I presume you'll be back next week and we'll take care of that then. So God willing, we'll be back here then next Monday. Everybody have a good week.